My name is Vanessa Farkas Brahmakshatriya. I'm here on behalf of the Canadian Centre for Men and Families, Alberta, where I'm a proud volunteer. I'm very pleased to introduce Charles Fair of Fair Legal. Charles has been practicing law for nearly 30 years and founded Fair Legal because he is passionate about helping others, ensuring that their rights are protected and that they are treated fairly. Fair Legal deals with criminal, family, and civil litigation matters, and Charles is generously volunteering his time with CCMF Alberta to deliver monthly webinars on topics of common concern to the population that we aim to serve. In other words, men struggling due to intimate relationship breakdown and turmoil. At CCMF Alberta, we are committed to meeting men where they're at so that they can feel heard and validated and have conversations that matter to them. We help equip men to manage stressful situations, rebuild their lives after relationships fail, and stay connected with children. We believe that providing mental health support for men leads to optimal parenting outcomes, a reduction in family violence, and lower rates of suicide. So this month's topic is what to do if you have been served with an emergency protection order. This may be an emotionally charged topic for some of you, and if that's the case, we're very glad to have you here and hope that Charles' expertise and insight can be of use to you. We also want to invite you to visit our website, which is ccmfalberta.ca. If you want to access additional supports in the form of individual or group peer support, domestic abuse trauma recovery, counseling, or other legal education programs like this one. So we do ask that you hold your questions until the Q&A period, or if you don't want to forget them, send them in the chat at any time to Melanie. Melanie is here as Charles' assistant. So she will be fielding the questions and reading them out for the Q&A. So again, if you have questions, send them by chat to Melanie, not to me, not to Charles. And above all, please be respectful of our guests and of your fellow participants. I'm going to ask that you keep your microphones muted and your cameras off, especially because we are recording and your privacy is important to us. So the last thing I want to mention is after the session, there will be a post-session survey in your email. So whichever email account you gave at the Eventbrite will have a survey with just a few questions about what you thought of the session and what other topics you'd like to see us cover in the future. Without further ado, Charles Fair, thank you very much for coming, and I look forward to hearing what you have to tell us.
Great, thank you very much, Vanessa. It is certainly an honor to be here assisting the Canadian Centre for Men and Families with your mission. I do represent both men and women in various messy situations they get into. And one of the things I like about CCMF is that it is not an organization that doesn't care about the rights of everybody involved in this, but is really focused on the rights or the special unique needs of men as they go through the breakdown of intimate partner relationships. I've been practicing law, as Vanessa said, for about 30 years, and it's always been important to me to really work towards getting the right result, the right resolution in very messy situations. And an emergency protection order is kind of ranks up there in terms of a messy situation that can arise in your life. And almost by definition, the EPO is going to come at you by surprise because it is obtained without notice to you, and we're going to go through that process. So it can cause a great deal of emotional turmoil when you get something like that. And it's important to reach out for assistance, and that's where CCMF has got some good resources there. It's also important to get good legal advice early on, almost as soon as possible, because there are things that you can do that are going to be very helpful in the situation. this is, we're going to cover off what is an EPO, what can an EPO do, what is the process, and how do you protect yourself. The emergency protection order is granted when violent or threatening behavior occurs, and there's evidence that immediate protection is necessary, that family violence will resume or continue. It's only granted in a family violence situation. So there has to be an intimate partner relationship. Sometimes it can be a parent-child relationship or a relative. It doesn't involve just family or stranger or workplace people. There are other court procedures for those sorts of things, but the EPO proceedings are just under the Protection Against Family Violence Act, and that is a specific provision that deals with family situations. It basically is intended to prevent a family member from contacting the person who's obtained the EPO and to stop them from contacting you at your home, your work, your school, or other places. If the EPO is not complied with, then it can result in a criminal conviction or criminal charges anyway. So, and then of course there's other proceedings involved in that. I do represent clients who are facing both EPOs in the civil side, which is what we're talking about today, and also on the criminal side, if there are related criminal charges. So I want to talk about the process here. So how does somebody get an EPO against you if without you even knowing about it? Well, the first thing is that they go and contact the police or the court directly. And then there's a questionnaire that is goes over, and if we've got some time, I'll figure out how to display a sample one of these questionnaires. It's the family violence investigative report questions that the police use, and the justice of the peace or provincial court judge will go through a similar set of questions. And those questions are very, very, very basic. And as a result of that, let me just see if I can, I don't know if you can, let's see if I can get that that document up here. My apologies here. Now, can you guys see this screen? Is this family violence? Okay, how about this here? I will just change this for. Okay, how's this? You see that? It should say family violence investigative report questions. Okay, so you'll see here that it covers there's kind of a checklist that the police or the justice of the peace will cover, make sure that they are covering what kind of relationship that we're dealing with. And you'll see that there's some very basic questions, and there's very short answers. And you'll see, and I've just taken an actual one that we got through the criminal disclosure proceedings, and I've deleted some of the or all of the identifiable information. But you'll see that there are certain questions here that can be easy to kind of fudge on the truth of the answer. And you'll see here, one of the questions is there previous domestic violence history? Is there a history of violence or abusive behavior in the relationship or with a previous intimate partner? It's an interesting answer here that says none reported. This question doesn't ask whether there's been anything reported. It asks whether there's a history. And this person, and the answer is telling, I think, and it actually resulted in this case with no restraining order ever being granted against the subject. So the complainant's attempt did not succeed here. But you'll see then there's other questions, is complainant's perception of compliance, Does the complainant believe the suspect will disobey terms of release? And this is a questionnaire that's used in the criminal charging context, as well as in the very similar questions for the EPO process. So then there's perception of safety, and you see again here, the question is complainant's perception of safety. Does the complainant fear for their safety or further violence to themselves, their children, or others? This is a really interesting answer to this question. It says supervised visit with their son are currently in place through family court. Well, those supervised visits were because there was allegations to the police. You can see how this kind of, but the police didn't do anything. So you can see how there's a bit of a feedback loop here that is can sometimes come into play here. You see alcohol and drugs, mental illness, suicidal ideation. These are all red flags for concerns that somebody is going to do something drastic. Then there's some questions about the relationship, escalation, and abuse. But you see, in each of these things, the question is very short. The answers are very short. Again, there's more questions here about threats, firearms, use of firearms. All of these are relevant to the context when they're trying to decide whether or not to grant one. All right, so going back to the are we back to the order here? Okay, back to the screen here. So after those questions are done, there's some screening questions. It ends up in front of a provincial court judge, and the provincial court judge has to make a decision as to whether to grant the EPO, and they will usually ask for some additional questions to get some details to kind of flesh out some of those very, very basic questions that have been answered. Now, if the EPO is granted by the Justice of the Peace or the provincial court judge, it has to be reviewed in the Court of Queen's Bench within 10 days. So this is a very temporary order. It's intended like a circuit breaker. It's just whatever's going on, stop. And so you can see that a judge or a justice of the peace hearing this application on the first go around is going to be very careful to not make an order when maybe they should have. So if they're going to err on the side probably of making the order rather than saying, oh well, there's not enough here, and so we're not going to make the order, so they're more likely to say, oh, there's enough and it doesn't have to be very much. And the reason why they can justify that is, well, yes, there's a restriction on your liberty, but it's only about 10 days before it's going to be reviewed in the Court of Queen's Bench. And that's the opportunity for the respondent to give their side of the story. So it's not a big concern. The EPO is that circuit breaker event. Let's everybody stop, calm down. Let's take it into Queen's Bench and see what happens. Now, then the police serve the EPO. I just want to make a comment about the involvement of the police. The police may or may not be involved. As a complainant can go directly to the provincial court. There's lots of assistance that is given to complainants in that case to facilitate making the complaint. They can go to the police, and the police will sometimes direct the complainant to go to court themselves, or sometimes the police have the authority to go to court. And then what happens is that they're interviewed by maybe they're the only one giving evidence before the provincial court judge. And essentially what they're doing is giving hearsay evidence based on the answers that they got to those very basic questions on that investigative seminar or questionnaire. So the police have an opportunity or the authority to go and make the application for an EPO, even if the complainant is not involved. And that's important because in cases of serious domestic violence, oftentimes the victim is really so concerned about their safety that they're afraid to do anything, or they're just in a frozen state. And sometimes the police will step in and act. If it's a really serious case, there's probably criminal charges pending, or maybe there's an arrest warrant out for the individual. And then what the police will do is they'll get the EPO, they'll serve all the papers and arrest the person and process them. And then typically in the criminal proceedings, the individual will be released, but the EPO remains in effect. So what happens then when it gets reviewed in the Court of Queen's Bench? So first off, and this is an important thing, is that a transcript from the proceedings in front of the Justice of the Peace or the provincial court judge are automatically prepared by the court. And any other evidence that's before the provincial court is sent up to the Queen's Bench. This is a procedure that is set out in the Protection Against Family Violence Act. It's mandatory, so there will always be a transcript. What's happened since COVID is that the written application or affidavit that may have been submitted in normal situation in support of the application seems to have fallen by the wayside, and these applications are now done via video conference or even telephone conference, and that other additional paperwork doesn't get included with the materials going up to the Queen's Bench because it doesn't exist. So in any event, the transcripts are prepared. They can be obtained by either the person who's the subject of the EPO, or they can be retained by or obtained from the court by counsel. It's a very short time period that you have to respond to the EPO. It has to be back in the Court of Queen's Bench within 10 days. And when it first gets back into court, the court has to make a decision on whether to continue the order and for how long, and whether there's any additional terms. It's important, if you have an opportunity, to get on this right away, to get that transcript and file an affidavit in response to it prior to that first hearing. If you don't, and that means that there's a very, very short time frame, because the transcripts are typically not available right away, and there's some delay, so you really may only have 2 or 3 days. Sometimes it has been and that's a discussion to have with your lawyer as to whether or not to file those proceedings, file that affidavit right away, or to ask for an adjournment. There are some advantages to not filing proceedings in that first place, but that's really a discussion you have to have with your lawyer, because if you don't file materials, then there is a risk that the court will just simply, if they think that you had enough time to file the materials, the court will just simply proceed as if you didn't, you had the opportunity, you didn't do it. So again, that's a tricky question to have, or discussion that you have to have with your lawyer. The Court of Queen's Bench then says, okay, we're going to either continue it, but if there is a contest or a dispute over the facts, then it will get put over to a review hearing, an oral hearing like a trial, and that's usually 2 or 3 months out, and it is a very short trial, and it's in part based on affidavits, and in part on the oral testimony during that trial. Question is, well, what happens in the meantime? What happens to that order? Does it continue, or does it fall by the wayside and then get reviewed later on? Well, the judge hearing it in Queen's Bench has got the first thing is there enough evidence that was in front of the provincial court judge to warrant a protection order? And if there was, then the judge will consider any evidence that's before him or her that's opposing it, and decide whether or not that evidence actually results in a real dispute, or whether somebody's the dispute, the response has nothing to do with the actual complaint. It's complaining about something else, in which case the judge says, well, it's pretty clear here, this EPO needs to be continued. It's hard if you're trying to represent yourself. I've got to say it's very, very hard to make sure that you are staying on point and concerned and dealing with exactly what the judge is going to be concerned about, because the judge doesn't have a whole lot of time. And so you need to make sure that your responding materials are dealing exactly with what the judge is wanting to hear about. If there is a dispute, then the matter will be put over for that oral hearing, as I said, and the judge is then in a very difficult position. And here's where there's some debate in the law, I suppose, as to what happens, because one resolution that sometimes can happen is, instead of a one-way protection order, or now at this point it's another name for it is a restraining order. The other way to resolve the issue is just simply say, well, everybody's in conflict. Well, let's continue the circuit breaker. Let's continue that no contact, and we'll everybody just agree not to contact each other until this mess can be sorted out. The problem is that the court probably doesn't have jurisdiction to grant a mutual no contact order without the consent of both parties. But that consent is something that's often a reasonable way to resolve the matter without it looking quite so much like there's terrible fault on one side. I was in court this morning, and a very senior judge was making a comment that in his view, it is problematic when a complainant comes in with a complaint about another person's behavior, and then they leave court with a mutual no contact order, which somehow says that they've done something wrong as well, or that there's a risk of them doing something wrong. So it's not guaranteed that a judge will grant a mutual no contact order. It is, but I got to say that's not a unitary position in the judges, at least not in my experience, although that was a very senior judge on that. One of the other things that will happen at the Court of Queen's Bench is now there's an opportunity to really fine-tune the terms of the order. So the justice of the peace may have got things wrong, or just not dealt with things, not have known the whole picture. So some of the things that can change are provisions dealing with well, what happens if you have children? You got to have parenting time. How do we allow contact to sort that out? For that circuit breaker period, that initial emergency protection order granted by the provincial court, more likely to say, look, no contact to anybody. Everybody, it's only 10 days. It's not the end of the world. Let's shut everything down for 10 days, no contact. But then once it gets into the Court of Queen's Bench, I say, okay, well, there's kids. The kids need to see their parent. Maybe it needs to be supervised, maybe not. So what they'll do is they'll say, okay, let's vary the order to or continue it along with some other terms that says, okay, the parties can contact each other through their lawyers. They can contact each other when they're in court, in the course of court proceedings. And that's not going to be a violation of that EPO. You want to make sure that the rules that are set out in that revised order in the Court of Queen's Bench are very clear. You got to say, well, what kinds of communication are allowed? Is it by email? Is it by text? Are phone calls allowed? Are phone calls not allowed? What topics can be discussed? And what's interesting about this process is that we assume that once that EPO process is going, it's really, really easy to say, oh my God, this is the end of the world. This is terrible. And then you go to the EPO, and I've had parties, we end up in the Queen's Bench review hearing, and the parties end up agreeing to an order that's almost as if the protection order never existed at all, and that's there's some interesting dynamics as to why that happens. So it's important when you've received an emergency protection order. It's really, really important to stay calm and say, wait a second, this isn't the end of the world necessarily. It might be, depending on on what the circumstances were that got you into this, but there's lots of different outcomes that are possible. Let's say here's a quote from the Alberta Court of Appeal recently, and just gives you an idea of this might be hard to read, so I'm just reading it out. Granting restraining orders always requires a careful balancing of the need to protect vulnerable domestic partners, while at the same time not unreasonably interfering with the liberty of the other spouse. The risk being ameliorated or dealt with must be objectively reasonable. Care must be taken that the hypervigilance of one spouse is not the basis for unreasonably restraining the liberty of the other spouse. The burden of proof is on the applicant to show that a restraining order is the appropriate response to the underlying problem. So you see, once you're into the Court of Queen's Bench, what's supposed to be happening is a very careful balancing of what the complainant's impression of their perception of the fear, their risk, with the respondent's right to have liberty, the right to go about their business without undue restrictions on their liberty. This is one of those things. This is the kind of the way the law is stated. But I got to say, judges are humans, and just like the rest of us, and they're going to have slight biases. There's going to be pressure, generally speaking, in the media and society in general. Those pressures will change from time to time, and sometimes what is viewed as maybe hypervigilance is kind of excused, and the subjective perception is of the complainant is validated. It says, well, that's good enough. If she's feeling unsafe, that's good enough. That's more important that people feel safe than the imposition on somebody's liberty. But that's not the law, but that is sometimes what happens. Now, getting close to the end of the 30 minutes, there's a kind of a short list here of things. How can you protect yourself when served with an EPO? The first thing is you got to stay calm and get counsel, get a lawyer. It's only a circuit breaker. It's not the end of the world. It can be if you don't handle it right. But sorry, I say that not the end of the world. That's overstating it. But it's important to stay calm, get a lawyer. The second point, don't try to change the other party's mind. Don't speak to them. Don't contact them. Don't violate the EPO. Do not sit outside their home or work hoping to have a chance to talk some sense into them. Don't even do anything nice. No gifts, no flowers, no cards. If you're allowed parenting time, don't include a little thank you card in with the kids stuff when you're shipping your little girl back. That will get you into trouble, and that will lead to criminal charges. And you go, how on earth do you does giving somebody a nice thank you card turn into criminal charges? Well, that's the way the law works. And so if you're in this situation, don't even do something nice until you've clarified in the Court of Queen's Bench with the review judge what the terms are of the restraining order or the emergency protection order going forward. And you got to do that, and you got to then stay strictly within those lines. If you're allowed to talk about the kids, talk about the kids. If you're allowed to talk about the finances, talk about the finances. If you're allowed to talk about the kids but not the finances, keep the discussion strictly to the topic that's allowed. Don't stray into things like, well, if we could save a lot of money with legal fees if you just agreed to something reasonable. Just don't do it. Anything straying out that will be grasped as an opportunity for the other side to make things worse for you. Okay. If parenting time with children is allowed, then when you have that parenting time, don't discuss the events or the EPO with the children. It's really not a burden that they need to carry. What will happen invariably is if you talk to them, they will, you say, well, look, this is what mommy or daddy did to me. They got this court order. The child is going to go back to the other parent and say, uh, daddy said this, that you did this, or mommy said you did this. And that is just going to land you in trouble. Okay, so I gotta say that, I just give an example. This is where I think that EPOs can be abused because getting a lawyer is way more expensive than making that initial threshold complaint to the police or to the court that gets your spouse out of your life. You get the kids, and sometimes it is subject to delay proceedings. So you can just see, I gave an example there. One parent makes a complaint to the police or the court. They ask for the EPO. The EPO is granted because it's only temporary. And hey, after all, it's going to be reviewed by the Court of Queen's Bench. The same parent then makes an application for sole custody or supervised access for the other parent. And then they say, well, there's this EPO pending, and now you're in a bit of a gong show as it's bouncing back and forth between the courts. The courts recognize that some of that happens. And so again, just because it's happening doesn't mean it's the end of the world. You've got to stay calm, get legal advice. It is possible to sort that stuff out. Every case is different. Get legal representation, follow the advice you get. And the other thing is have realistic expectations. Every case is different. And maybe you do have a problem with anger management. Maybe you do have a problem. And the more times I do this, I start peeling away the onion and there's layers, and I go, there's always more to this. Very rarely have I met somebody who's truly evil to the core and irredeemable. There's almost always things that can be done to make things better. Sometimes there's struggles with substance abuse or your own childhood experience of abuse or dysfunctional families. It's part of life. Every case is different. Have realistic expectations and accept what you can and you cannot change. So those are my comments. We are your champions for justice when life gets messy. So there you go. It's open for questions.
Awesome. All right. You can hear me, right, Charles?
Yes.
Okay. So we've got a couple of questions here. The first one is, what if the police filed for the EPO on behalf of the claimant with false information added by the police?
Well, that's the interesting thing. The transcript is prepared, as I said, by the provincial court judge. It goes to the Queen's Bench, and you can state that it's false. Unfortunately, because of that, now because of COVID, because there's the underlying affidavit isn't always there, that sometimes there's it's hard to catch that discrepancy. If there are criminal charges, then the police will have to provide full disclosure in the context of bail hearings and that sort of thing. And so sometimes you can get at the false statements there. Unfortunately, society has this belief that if you're charged with a crime, then you're more likely than not guilty. Well, we do have a presumption of innocence, and I've got to say, since I've been doing criminal law, I'm always amazed and somewhat disappointed at the number of times that the police are less than accurate in their write-ups, that their summaries of the case that they then put on to the Crown. in order for the purpose of, instructing the Crown prosecutor on how to proceed. There's missing facts, there's misstatements of facts. When they're doing interviewing of witnesses, they don't ask for questions that I think would be obvious questions to ask. And so there's no easy answer for what happens if there's falsehood. What I do as a lawyer is I look for red flags or signals that there's likely a problem, and start unpacking that. And it's hard. I got to say, sometimes it's hard to. It's difficult sometimes to get at that falsehood. But if the matter is set down for an oral hearing in the Court of Queen's Bench, the falsehoods are going to be harder to keep going that long. So it might take a little longer to get rid of the restraint. But if the falsehoods are really, really serious, then it will end sooner rather than later. And sometimes the other side can be convinced to drop it.
Okay, great. The next question, what if the EPO hearing, and it says asked for a hearing as it was false allegations, is denied due to counsel not showing up, and the EPO is then converted to an MRO, so a mutual restraining order, and the applicant then continually and repeatedly breaches the MRO?
Well, there's probably too much detail in there that gives is an opportunity. Sorry, there's probably a little bit more detail in there that I can really properly speak to in this setting. But this is one of the difficulties with the mutual restraining order, or the mutual no contact order, that it's that if there is not truly consent, it probably shouldn't be granted. And if somebody isn't showing up, if the complainant's isn't showing up, or the complainant's lawyer isn't showing up, then the court probably should just be dismissing the thing altogether. Just because you've made the application doesn't mean it's guaranteed. Now, if it's the respondent that's not showing up, the respondent's lawyer, if it depends on which side of this you're on. If you're a complainant or in the complainant, usually there's duty counsel that will assist, and their job is to kind of process all of these things. So the complainant will typically have at least some representation, and there should be duty counsel available for the subjects of the proceedings. But if there's no duty counsel and you don't have a lawyer, don't agree to an order. Just ask it to be put over for a few days or a few weeks. Now, where the tricky part here is, it sounds like the person who's the complainant is continuing to contact the person. Well, that puts you into a very, very difficult situation. And the advice is, if you see that if you're the subject of an EPO or a restraining order, or mutual no contact order or anything, and you see that it's the complainant that is calling you or sending you a text, do not respond, do not pick up the phone, do not engage. You would be amazed. You would think, well, they're the ones who are initiating the contact. Yeah, but you don't have to pick up the phone. It's no fun being dragged into court in handcuffs in an orange suit, having to explain that I thought that there was some change or some emergency. I needed to answer the phone. And then you get released from jail. Yeah, that's fine after you've spent a day or two in jail. And the judge says, well, I'm not going to keep you in jail because after all, it was, you didn't initiate this, but don't pick up the phone. It's not worth getting that lecture. And I've been in court and heard that lecture. So don't engage is probably the number one thing, but you also need to keep a record of it, because how can the person be afraid for their safety if they're continuing to contact you? That's one of those red flags that we look for, those signs that there's something amiss with the whole proceedings.
Okay. Next question is there any way to obtain the EPO application that was filed?
yes, as I said, the transcript of the proceedings is has to be done by statute, and any other materials that were before the court must be provided to the Court of Queen's Bench. And if they're not, I think that you're entitled to kick up a fuss and say, look, we're not proceeding until those proceedings, or it shouldn't be continued if there's been a violation of that statute. The problem has been, because of COVID, the underlying application was done by phone and doesn't actually exist. And I think that's a problem that hasn't been adequately addressed. So far, when I've run into it in my practice, I've been able to sidestep the issue and get to a resolution that we didn't have to confront that issue head on.
Okay. Is there any suggested wording that can be added at the 10-day mark that can open up more communication with positive change to help bridge a healthy interaction with the best interest of the child in mind?
Oh, sure. Yeah. And I got to say, I had one where the first review order, it was gutted so badly that there was hardly anything left. And then my client purchased a home 2 doors down from his own home so that his ex could rent it from him, so that the kid would be like 2 doors away. Anything is possible with consent. The judge is, if you're asking the judge for an order that says allows for some kind of counseling, one term that I've seen is that they will allow for counseling, contact during counseling, or mediation or other court processes. I wouldn't expect to see more lovey-dovey language than that. Sorry, I don't mean to lessen that. Okay.
Okay. So here is a scenario, I guess. So it says, my ex-spouse has been sending me random messages once a month or every second month through email and WhatsApp that she wants to reconcile and we should meet to discuss. End of September 2021, she mentioned in email she was walking close to my workplace. Do I have enough grounds to file an EPO against her? It has been suggested by my lawyer to ignore her messages.
I'm going to talk a little bit about what I do when I'm consulted by somebody who wants to get a restraining order. You really, and going back to what the court's concerned about, you're asking to restrain somebody's liberty, and I think that there has to be a legitimate concern for your safety. If it's just an annoyance, there's much easier ways to deal with it. And, it's just simply by ignoring the behavior. If there's a risk of harm, sometimes it's safer to take steps to minimize that risk without applying for a restraining order, because sometimes restraining orders, regrettably, can inflame the situation. And one of the things that I think is important in this is we tend to see the legal system in kind of these black and white terms. This is some kind of machine. It's not. This is real people are involved here with real emotional needs or sociological needs or whatever's going on. And sometimes legal proceedings are brought because there's an underlying need to engage in kind of a weird tango with your ex. So I don't know what's going on. If somebody wants to get a restraining order and there really isn't enough to get a restraining order objectively, I would caution against it. But then the question is, well, why is this necessary? What else is going on? Because it may be that there's other stuff that's underlying this that isn't coming to the surface. And maybe that's something that is best not dealt with in the courts, but dealt with elsewhere, through counseling or whatever.
Okay. So the next question I'm going to ask is, what is the difference between an EPO, Queen's Bench Protection Order, a restraining order, and an undertaking to stay away from someone?
Well, they're all similar in the sense that they are, the goal is the same, is to restrain somebody's liberty for the protection of another person. The Queen's Bench, and some of it is based on the underlying statute. So the EPO, the Emergency Protection Order, is something that is only granted under the Protection Against Family Violence Act, so it only applies to intimate partner situations. A Queen's Bench restraining order can be obtained in any kind of situation, a dispute between co-workers that's spun out of control can be dealt with a Queen's Bench restraining order. The other thing that happens with a Queen's Bench restraining order is it's typically done with notice to the other party. So you can still do it without notice application in the Court of Queen's Bench, but you're going to have to really satisfy a Queen's Bench judge that you need it without notice, because otherwise they're going to say, well, let's hear the other side of the story right off the bat. What was the other one? The Queen's Bench restraining order, the EPO, the undertaking to not contact somebody. The undertaking not to contact somebody is typically done as part of release conditions under the criminal proceedings. So if there's a violation of those, that's a criminal offense, just like it would be a criminal offense to violate the EPO or restraining order.
Okay, I'm gonna throw about 3 questions together. So far, 3 that I've seen that all are relating to false allegations. One thing I'm going to reference for anybody who hasn't seen, Charles did a webinar back in September regarding false allegations. So feel free to either look on CCMF's website, our website, or our YouTube page for that recording of that video. So there's going to be 3 separate questions, Charles, but they're all related. Okay.
Okay.
So first off, are there repercussions for the person making false allegations, especially if it has been done multiple times? Second question, why does there seem to be no consequences for false allegations resulting in a life-damaging EPO? And the third one, the initial allegation on which the arrest was made was confirmed to be false during detailed statements by the complainant. Why did the police not charge the complainant for misguiding, and what can be done to take action?
Okay. I'm going to deal with the second one first, because read the second one again.
Oh, hold on a second. Just a second. Hold on. Where is it now? The second one, sorry. I just lost where I put it. Why does there seem to be no consequences for false allegations resulting in a life-damaging EPO?
Okay. The reason why I wanted to start with that one is because the EPO is that circuit breaker event, and it only lasts 10 days. So it shouldn't be life-damaging. If it is life-damaging, it's because it wasn't handled correctly at that initial Queen's Bench stage. The question about, it's really arising out of the issue of false accusations, and these are serious, and the court is aware that these can happen. And the court is, and sometimes the court will step in to make an order that deals with it. And there's 2 kinds. The third question dealt with why don't the police charge the complainant with mischief, which is the criminal charge that would be applicable in that case. I think the police are really reluctant to wade into that situation, largely because of the Me Too movement and those kinds of social pressures. So I think the police are under a fair bit of pressure to not disbelieve a complainant. Kind of like the EPO judge first hearing it, the provincial court judge or the justice of the peace are figuring, you know what, better be safe. I'm going to make a decision. The safe decision is always the protective order, pass it off to somebody else. And that's been the concern I've had, is that oftentimes the police aren't asking the right questions. And one case that I had, after the Crown withdrew the charges in the middle of the trial, I wrote to the Crown and said, you know, why aren't the police getting better training and on how to do these things right? And the Crown never replied to me. You know, I got other things to do than try to fix the police system. And not to say that the police have got a tough job, and I'm in no way anti-police. I've got military background myself. You know, police have got a very difficult job. I respect what they do. Sometimes I think they should make those decisions, but they don't. Now back to the first question then is well, what happens in family context when you got somebody who's continuing to make false allegations? Well, probably the biggest difficulty is you've got to really, really establish that they are making false accusations, that they are vexatious litigants. Getting to a conclusive court finding on that can be very difficult and expensive, because what happens is the court is typically making decisions in the short term based on affidavit evidence. And if you've got, you know, if it's a he said, she said kind of thing, with one affidavit says one thing and the other affidavit says the other thing, the court really doesn't have any basis for deciding who's telling the truth until there's a trial. And that trial, if it's an oral hearing under an EPO, that trial is only going to be, it's going to be, 3, 4, 5 months away, and it's going to be a very short trial, possibly less than an hour total length. And that's just not very much time to decide anything other than, we got enough. We're going to leave this thing alone. We'll leave the restraining order or the EPO in place, or there's not enough here and it's, or enough time has passed and we're just going to let it go. My lights just turned off. Melanie, can you go turn those lights back on for me? So the issue then is will the courts take action? They will. It does take some time to get to that point, unfortunately, but the courts do have several ways to deal with it. In extreme cases, they will change custody of children. They can impose orders that vexatious litigants not be allowed to file applications without actually getting court approval to file the application. So first they've got to apply to the court for permission to file their application. And that's, the courts do make those kinds of orders from time to time. But when it comes to the changing custody of the kids, I mean, think about it. You got to be really, really sure that the kids are going to be better off with that change in custody. And that's not always clear to the court, because now you're dealing with a different test, which is best interest of the kids. And that may not sit well with, okay, well, the parent who's got the kids is making these false accusations, but is it enough to change custody? That's where you got some difficulties there. And unfortunately, and this is where I think CCMF is really right to identify some of these issues, because it's partly it's an access to justice issue. It's a systemic problem. How do we sort this stuff out without losing some of the benefits that we have of a traditional legal system, like presumption of innocence until proven guilty? The opportunity to hear from both sides and make a decision based on hearing both sides of the story. Those are two very important legal concepts that don't jive very well with fixing some of these problems of false accusations.
Okay, thanks. I know we're coming up on time, but if people want to stay on, we'll go an extra maybe 10, 15 minutes, if that's okay, Vanessa, because we have a few more questions can try to
That's
address.
perfectly fine with me.
Okay, great.
Okay, you can always tell me to shorten my answers if you want.
We got a few more, so some of them may be a little in depth. Okay, so I'm going to throw two questions together that came from the same person, but they're kind of related. So the first one is, what is the typical time frame from the complainant and completion of the questionnaire to a hearing, then, if granted, to when the EPO is served? And then the second part of that question is, if an EPO is granted for the 10 days and then dismissed, is it on my record?
Okay, the last question's the easiest. The EPO is not a criminal charge. The fact that it's granted is not a criminal conviction. That's the good news. I should have made that clearer. An EPO is not a criminal charge. It's not, and the fact that one is granted is not a criminal conviction. Now, the question of how long it takes, well, it really depends on how urgent the various participants view this matter. It doesn't take very long to get in front of a justice of the peace. In fact, they actually are available 24 hours a day, 7 days a week. I think there might now be a gap in that. I don't know, but it is quite easy to get in quickly in front of a justice of the peace. Sometimes within hours, sometimes might be a day, and then after that, the time getting it to serve is, it goes into the regular process. And then the question is, well, how long does it take the police to serve the order? Well, if the person can be found quickly and it's regarded as urgent, then they'll serve it quickly. My experience, they tend to get those things served fairly quickly. And of course, if they delay, that creates a problem. Now, if you violate the EPO before you've been served with it, it's actually not a violation. What the police are obliged to do is tell you, hey, look, I've got this. We've got this EPO here that we have to serve on you. Now you're served. Now you need to comply. You either comply now or right away, or we'll charge you, right? So they have to follow that kind of process. They can't just charge you because there's a complaint that's been made if you haven't been served.
Okay. The next one is, I guess it's kind of a scenario. After my former partner filed for the EPO, she moved out of the family home and took the contents and kids to an undisclosed location. She has refused to disclose it to my counsel. The EPO was replaced with a restraining order without prejudice, and neither order contained any conditions regarding restricting my knowledge of where my children are housed and what conditions they are under. Do I have a right to know where they are?
So the answer is yes, and this is where you need to deal with that in the family courts, because the family courts, whether in Queen's Bench or in provincial court family, that's the best place to deal with that issue. But if there's an underlying restraining order or EPO, you're going to also have to deal with that in the family court. If somebody is withholding parenting children from the other parent and they don't have the legal authority to do so, it's actually a criminal offense if it gets to that stage. So, but there's a lot of steps that have to be involved. You have to deal with it in family law. If the order doesn't say that you're, well, here's the thing: on a restraining order, typically they'll say, well, you can't go within 200 meters of where the person lives. Well, doesn't that mean you have to know where the person lives? which is kind of a quandary. If you don't know where they live, you could find yourself in violation of it at any time. So clearly, it's going to be difficult to sustain a charge for violating an order if you don't know where the person lives, and it doesn't say where you're supposed to stay away from. It's not impossible to get convicted in that kind of thing, but you really do need to get your orders in the family court in that situation, because the family court is going to be concerned with what's in the best interest of the children, and the parent has the right to information, unless it's in the children's best interest not to have that information, and that's going to be tough unless there's a real risk of safety concerns. And that's where the EPO process and the restraining order process is subject to abuse, because the complainant can get an easy, cheap, they don't have to retain a lawyer, they just have to sound convincing enough times, and then they get a de facto family court order that's very expensive to deal with.
Okay, sounds great. The next question is, how does one put over an order that means they are not able to see their children? By this question, I do not mean the process. I'm referring to the emotional angst and damage to the parenting relationship that this is creating. Police officers and third parties may often bring the evidence before a JP to seek an EPO. This is essentially hearsay evidence, which typically in a court proceeding is insufficient to get such a restriction on a person. Yet it is accepted in EPOs. Why? And is this a violation of one being able to face their accuser? Deep question.
Well, yeah, and in my case this morning, I raised that very issue, and I can it wasn't an EPO case, but it was a change in parenting, an application to make a substantial change to a parenting arrangement, and there were lots of allegations about what the children were saying, and the judge was very cautious about wholeheartedly believing it, but said, if the children, his answer went along something like this, is there's a difference between, coaching your children to say something and then saying this is what they're saying, or interrogating the children to drag out of them what you want them to say, or the children come to you with a concern about the other parent, and what are you supposed to do? Plug your ears? So the cat's out of the bag. Well, then the question is, so it's what the court did this morning is that they appointed counsel for the children, so to kind of get to the bottom of where the children were at. The issue of hearsay in the EPO, that initial EPO context, it's a balancing issue. You allow it in that first stage, so you get that 10-day circuit breaker, and then you're into the Court of Queen's Bench, and then you can challenge that. And if the complainant isn't willing to carry on at that initial stage, then in that case, what happens is that the EPO is not continued, and that can and does happen. That's, just because, I think that sometimes what happens is a complainant gets talked into this procedure, by friends, overactive busybodies, well, whatever. I don't mean to say that, but they can get talked into doing stuff, or the police, the police don't ask enough questions, and they get all, they jump to conclusions, and they go get the order, and then it gets into Queen's Bench, and then the complainant says, well, I'm not real happy with what's going on here. They start to feel maybe a little guilty about it. Maybe they start feeling, well, this isn't really what I think is in the children's best interests, and then you get a little bit more of a nuanced response. I don't know. Did that answer that question?
a roundabout way, yes. I think so. So we're just going to do about 3 more questions. Hopefully it won't be too long. So an EPO morphed into a MRO, mutual restraining order. The MRO has expired approximately 1 year ago. What's the expected impact during upcoming high conflict custody / divorce proceedings?
Well, from a process point of view, the courts actually don't like seeing the restraining order stuff on the same court proceedings as the family stuff. So they say, yeah, okay, we know, we understand that there's proceedings there, and so remember that circuit breaker principle operates for that first 10 days, but it's typically not a lifetime ban. And the idea is, well, after a year, surely people have calmed down. What you're talking about now is a high conflict situation, which means the dispute is still carrying on. Now that the thing is over, doesn't give you license to go do what you shouldn't have been doing in the first place that got you into that pickle. So just because the order's expired doesn't mean, wahoo, I get to go and be obnoxious and stir the pot in some other way. Now, what it does mean is if your communications with your ex are polite and respectful and staying to the topic, and they go and complain, you go, look, there's something wrong here. She's complaining, or he's complaining about just normal, polite, respectful communication. But they recognize when you got a high conflict situation, it's hard to see through the chaos that's going on and seeing what's clear. And what I often say is, look, the bottom line is you just got to focus on your kids. You can't solve all aspects of the dispute with your ex, but when you got kids, you can just focus on your kids, on your relationship with your kids. What's in their best interest? What's good for them? Focus on what they're interested on and ignore the rest. You don't have to fight every fight in a high conflict divorce.
So the second last question, from your practice and life experience, what % of EPOs do you feel are false or unnecessary and done for the purpose of gain by one party?
Well, I'm not sure that I can give a fair representation of what the overall situation is. I typically just represent good people. And I don't mean that lightly. I did have a client that was in custody on a very, very serious domestic violence charges, serious long-term physical injuries, and the police had him recorded phone calls out of the remand with a friend outside that were surely suggestive of continued risk of violence to the complainant. So that client, had some real baggage that he had to deal with, I think would be the fairest way to say it. And, I was working with them because the fact that somebody's made a mistake doesn't mean that they're not entitled to legal representation. So I say, I only represent good people. I do represent people across the spectrum of this stuff. And in that case, when I tried to broach the subject of, we maybe need to take a look at what's going on here with your behavior, within a couple of days, he'd fired me. So, I say that's because now he fired me. Things didn't go particularly well for him after that. And a year later, his mother called me wanting to know whether I'd be interested in taking him on again. So it's an interesting dynamic when that happens. But I think of resolving court cases as more than just getting to a win-loss. It's not about a score on a win-loss column. It's about trying to figure out how to make the situation better. So as a result, my perspective of it is, well, I think that a lot of these restraining orders are probably unnecessary, but the system doesn't really know how to deal with it any other way. You go onto, and multiple websites are out there. If you're in an abusive relationship, get yourself safe and go apply for a restraining order. That's the advice again and again and again. Well, I'm not sure that's a I would prefer to see a much more nuanced approach, but that's me and my rosy-eyed view of the world.
Okay, and so the last question we're going to take today, and I do apologize that there's a few people that we didn't get to. Is there any avenues that you can suggest to help bridge the triangle outside of legal work? So other courses or programs, of course, other than CCMF?
Well, there's some interesting programs on that there are some social workers who've got experience in doing child custody evaluations and that sort of thing. There's social workers or counselors or psychologists that specialize in repairing broken relationships with kids. There are court orders that contemplate, like a practice note 7 intervention in the Court of Queen's Bench, contemplates measures to restore the relationship between a parent and child. So there are resources out there, and I think CCMF is a great resource because the biggest problem, or the big problem, I think, is you're feeling like you're alone and the world is against you. You're thinking that the system is biased in favor of women or men or whatever it is you think the bias is, and it's important to be able to talk that stuff through with people and realize that you're not alone on this, and it's important to get context and say, okay, I'm not, I may have made a mistake, maybe I didn't make a mistake, maybe the other side's made a mistake, but there's always some kind of solution to it. Sorry, I started to ramble there, didn't I?
A little bit, but I'm going to throw one more question really quickly out and try not to make it too long of an answer, not ramble. Okay. So do you think that the EPO process is abused and broken? Yes or no? And then either way, why is this? Is it, if it's broken, is it because of money, career, or why do the agents within the system, those most to be able to affect change, fail to do so? It's kind of a loaded question.
Well, yeah, it's kind of beyond my pay grade. Here's the problem with the court system in general. It's based on a feudal power structure from medieval England and France, dealing with feudal lords, and that's where a lot of the court system and rules came into play, and so it has a kind of a unitary focus on how to fix things, and a restraining order seems to be like, well, that's what you do. It's kind of like putting somebody in jail, because that's what that feudal power structure thing does. But think about, what would the alternative be? So if you don't do that, what you compel somebody to take psychoactive drugs to fix what kind of problem you think they have? So it's a difficult question. I do think that because they can be given out almost like candy, there are some risks of abuse. But if you go look at how the legislation is actually structured, it's structured to have safeguards in there. And what's interesting is that the Protection Against Family Violence Act begins with, the first preamble is, the legislature recognizes that the family is the basic unit of society. I don't know whether that is is really regarded when the courts are making a decision, but there's at least the thought that what we should be doing is trying to preserve family relationships rather than weighing in with a hammer to try to fix something. So I don't know. Maybe I showed my bias on that. As I say, I represent both women and men, and on both sides of restraining order and EPO applications. Sometimes they're necessary, sometimes they're abused. How was that for a lawyer's answer?
I think that was a wonderful answer. So was that all of the questions, Melanie?
Yeah, that's all that will do today. There was some more, but we
Okay.
just can't get to them all. So I apologize for
Okay.
that.
And
Well,
you know, you can always reach out to Melanie and you know, schedule something. We can maybe, or maybe Vanessa's going to comment on that. I don't know. I always like to help.
Oh, that's a very kind offer. And I also I wanted to make, by way of some closing remarks, particularly for anyone who wasn't here for my opening remarks, that that CCMF Alberta, the Canadian Centre for Men and Families Alberta, that put on this presentation with Charles. And by the way, Charles, thank you so much for that rich, informative, and sensitive presentation. We will be putting on more of these in the future from Charles and from other volunteer lawyers. But if you're here at all, I am positive that you're under tremendous stress. So I'd really like to encourage you to visit our website at ccmfalberta.ca to learn more about our programs to support you if you are experiencing intimate partner breakdown or any kind of aftermath of that with your family, with family court, with domestic violence recovery, with trying to keep connected with your children. We offer a variety of programs, and including the kind of peer support that Charles sort of alluded to when he said that you're not alone. We have a lot of amazing guys in our groups that have a lot of experience and are here to help you. So ccmfalberta.ca, please come shore up your mental health with us and avail yourself of more of our legal education programs. So thank you for coming. Thank you, Charles. Thank you, Melanie. And we'll see you next time.
Hey, thank you.